On the case of dispute on reclaiming property. Part 1. Source of the case law. Part 2. Overview of the case law. Part 3. Content of the case. Part 4. Assessment of the court. Part 5. Rules. This case law was adopted by the Judicial Council of the Supreme People's Court on April 6, 2016. And promulgated under Decision Number 220.QDCA dated April 6, 2016 by the Chief Justice of the Supreme People's Court. Part 1. Source of the case law. Cassation Decision Number 27-2010 DSGDT dated July 8, 2010. By the Judicial Council of the Supreme People's Court on dispute on reclaiming property. In Sok Trang Province between Mr. Nguyen Van Dam, the defendant. Ms. Nguyen T Tan, the plaintiff. Ms. Nguyen T M, the person with related rights and obligations. Part 2. Overview of the case law. Case law situation. When an overseas Vietnamese purchases land use right and asks another person residing in Vietnam to receive transfer of such land use right on behalf of him. Legal resolution. The court shall review and consider any contributions of the person receiving transfer of the land use rights in preserving, managing, and enhancing the value of the land use right, in case such contributions cannot be determined exactly. The court rules that the person actually making payment for the land use right and the person receiving transfer of the land use right shall have the equal shares in the increased value of the land use right. Keywords of the case law. Invalid civil transaction. Reclaiming property. Basis for establishing ownership rights. Establishing ownership rights over profits. Vietnamese residing abroad. Part 3. Content of the case. In the Statement of Claims dated January 24, 2005, written testimony dated February 7, 2005 and the resolution process of the case. The plaintiff Ms. Nguyen T Tan presented. Ms. Tan is an overseas Vietnamese in the Netherlands who was visiting her relatives in Vietnam and she intended to transfer land use rights. Thus, on August 10, 1993, she received the transfer of the land use rights from the couple Hang Tan and Ly T Sequen for the area of 7,597.7 square meters of farmland at Ward 7, Sok Trang Town, for the price of 2.199 taels of gold. Ms. Tan was the person directly transacting and agreeing to the transfer and payment of money and gold to the couple Hang Tan. Ms. Tan intended to transfer the land to her younger brother Mr. Nguyen Van Dam and Ms. Nguyen T Chi Nam to cultivate crops and support her and Mr. Dam's parents. Since Ms. Tan is a Vietnamese living abroad, she let Mr. Tam to be the transferee in documents. In addition, Ms. Tan submitted the record on transfer of farmland established on August 10, 1993 with the confirmation of the People's Committee of An Hiệp Commune. After receiving transfer, she let Mr. Tam and his wife cultivate the land. However, in 2004, without Ms. Tan's consent, Mr. Tam transferred the entire area of farmland, being 7,595.7 square meters, to Minh Chau Company Limited with the value of the land use rights being VND 1,260,000,000. For this reason, Ms. Tan requested Mr. Tam to pay her all the money from the transfer of her land. The defendant, Mr. Nguyen Van Dam, presented. He opined that the record on transfer of farmland established on August 10, 1993 with the confirmation of the People's Committee of An Hiệp Commune submitted by Ms. Tan was fake, and based on the conclusion of Assessment Report No. 2784 C21, P7, dated October 25, 2005 of the Criminal Science Institute, General Police Department. It was not his signature in the farmland transfer documents that Ms. Tan submitted. Therefore, he did not agree to Ms. Tan's claim. Ms. Nguyen T. Mr. Tam's wife, as a person with related rights and obligations presented. In 1993, she and her husband received the transfer of land use right from Mr. Heng Ten. During the transfer procedures, she did not participate, however. She did give money and gold to Mr. Tam to pay Mr. Heng Ten and his wife. For this reason, she also did not agree to Ms. Tan's claim. The couple Mr. Heng Ten and Ms. Letisa Nguyen, the other name is Letisa Vin, being the transferors in the transaction. Both confirmed that Ms. Tan directly transacted the transfer and directly paid 2.199 taels of gold to them. Ms. Nguyen and Ms. Tan agreed to let Mr. Tam be the transferee on the record on transfer of farmland established on August 10, 1993. The signatures on the record on transfer of farmland submitted by Ms. Tan were hers and her husband's. In first instance civil judgment number 04.2006.DSST dated April 28, 2006, the People's Court of Sok Trang Province ruled that accept a part of Ms. Tan's claim on reclaiming the money on the transfer of the land use right. Compel Mr. Tam and his wife to pay Ms. Tan the amount of VND 630 million. Besides, the first instance judgment ruled on the court fees, assessment fees, and granted the involved parties the appellate rights in accordance with the laws. On May 10, 2006, Nguyen Van Tam submitted an appeal against the first instance judgment. He argued that Ms. Tan was not the one to have the right to use the area of land which was transferred to Min Chau Company Limited. Therefore, the first instance court's decision to compel him to pay Ms. Tan the amount of VND 630 million is not correct. On May 12, 2006, Mr. Nguyen Hu Phan, representative of Ms. Tan, submitted an appeal, proposing that the appellate court to consider compelling Mr. Tam to pay the entire amount for the land transfer being VND 1,260 million to Ms. Tan. In appellate civil judgment number 334/2006 DSPT dated August 25, 2006, the appellate court of the Supreme People's Court in Ho Chi Minh City ruled. It rejected the appeals of both the plaintiff and the defendant. Moreover, the first instance judgment was amended as follows. Accept a part of Ms. Tan's claim on reclaiming the money on the transfer of the land use right. Compel Mr. Nguyen Van Tam and Ms. Nguyen T. to pay Ms. Tan the amount of VND 27,047,000. Equivalent to 2.199 taels of gold. Compel Mr. Nguyen Van Tam and Nguyen T. to submit the amount of VND 1,232,266,860 to the state budget. Besides, the appellate court also ruled on the court fees. In decision number 449/2009 Knots DES on August 21, 2009, the Chief Justice of the Supreme People's Court protested appellate civil judgment number 334/2006 DSPT dated August 25, 2006 of the Appellate Court of the Supreme People's Court in Ho Chi Minh City, proposing that the Judicial Council of the Supreme People's Court conduct cassation procedures, set aside the appellate judgment and first instance civil judgment number 04/2006 DSST dated April 28, 2006 of the People's Court of Sok Trang Province. Assign the case to the People's Court of Sok Trang Province to conduct first instance procedures in accordance with the laws. The Chief Justice finds Ms. Nguyen T. Tan initiated a lawsuit to reclaim property from Mr. Nguyen Van Tam, and opined that since she is a Vietnamese living abroad, she had asked Mr. Tam, her younger brother, received transfer of the land use right from Mr. Heng Ten and his wife. The first instance court and the appellate court determined that Mr. Tam was the transferee for the transfer of land use rights from Mr. Heng Ten and his wife on behalf of Ms. Tan, which there is basis. Since Ms. Tan was a Vietnamese living abroad, she was not entitled to receive transfer of the land use right but is only entitled to part of the investment value for the land transfer. Concerning the difference in value of the land, the time when the first instance hearing and the appellate hearing were conducted was subject to the regulations of the Civil Code 2005. And there were no provisions to compel parties to submit to the budget, and thus, this difference in value belongs to Ms. Tan and Mr. Tam. The first instance court did not compel Mr. Tam to submit the value of the difference to the budget, which there is basis. However, it did not compel him to pay the initial investment value to Ms. Tan. The appellate court did not have a legal basis, but compelled Mr. Tam to submit the entire difference in value, VND 1,232,226,860, to the state budget, which is not in accordance with law. At the cassation hearing, the representative of the Supreme People's Procuracy suggested the Judicial Council of the Supreme People's Court to accept the protest of the Chief Justice of the Supreme People's Court to set aside the above appellate judgment and first instance civil judgment number 04/2006 DSST dated April 28, 2006 of the People's Court of Sok Train Province. Transfer the case to the People's Court of Sok Train Province to conduct the first instance procedures in accordance with laws. Part 4. Assessment of the Court. Ms. Nguyen T. Tan initiated a lawsuit against Mr. Nguyen Van Tam to claim the amount of VND 1,260,000,000. Because she was the person directly transacting and paying for the transfer of the area of 7,595.7 square meters from Mr. Hang Tan and his wife. However, since she is a Vietnamese living abroad, she asked Mr. Tam, her younger brother, to be the transferee. Without Ms. Tan's consent, Mr. Tam transferred the land use right to Minh Chau Company Limited for the amount of VND 1,260,000,000. Mr. Tam stated that he was the person agreeing with and paying Mr. Hang Tan. Thus, he is recorded as the transferee. After he received the transfer, he directly managed and used, registered and declared, and was granted the certificate of land use right. Moreover, when he transferred to Minh Chau Company Limited, the transfer was approved by the local authorities. For this reason, he did not accept Ms. Tan's claim. However, during the resolution process of the case, Mr. Tam and his wife had conflicting testimonies concerning the amount of money and gold paid to Mr. Hang Tan. Furthermore, Mr. Tam also could not prove the origin of the money and gold that he paid to Mr. Hang Tan. On the other hand, Mr. Hang Tan and his wife, as the transferors, confirmed that they agreed on the transfer with and received gold from Ms. Tan only. Writing the land transfer documents with Mr. Tam's name was due to Ms. Tan's request because Ms. Tan was living abroad at that time. In the testimonies of Ms. Tai Thi Ba, Mr. Nguyen Phu Hoang, and Ms. Nguyen Thi Chin M, the mother and siblings of Mr. Tam and Ms. Tan, Ms. Tan was the person transacting and paying Mr. Hang Tan and his wife. Mr. Tam was just the transferee on behalf of Ms. Tan. In the light of all evidences above, there is a basis to conclude that the first instance court and the appellate court were correct to determine that Ms. Tan was the one who paid the amount being 2.199 taels of gold to receive transfer of the above land area. Mr. Tam is only the transferee on behalf of Ms. Tan. Since Mr. Tam had already transferred the land use right to Minh Chau Company Limited, and Ms. Tan only requested that he pay the transfer price, VND 1,260,000,000. The first instance courts and appellate court's acceptance to resolve the case is in accordance with law. Although Ms. Tan was the person who paid 2.199 taels of gold for the land transfer, equivalent to VND 27,047,700, the transfer documents recorded the name of Mr. Tam. And after receiving transfer, Mr. Tam managed the land, and then transferred it to another party. Therefore, the court should have determined that Mr. Tam contributed to the preservation, management and enhancement of the value of the area of farmland, so that the above-mentioned amount of money, after deducting Ms. Tan's initial amount equivalent to 2.199 taels of gold, is the joint profits of both Mr. Tam and Ms. Tan. Moreover, Mr. Tam's contributions must be taken into account when determining the lawful rights and interests of the involved parties. In case it is impossible to exactly determine Mr. Tam's contributions, it should be determined that Mr. Tam and Ms. Tan have the equal shares. The first instance court recognized that Mr. Tam and Ms. Tan each has ownership over a half of such above-mentioned amount of money without paying Ms. Tan the amount of 2.199 taels of gold, which is not correct. The appellate court only recognized that Ms. Tan was only entitled to the amount of money equivalent to 2.199 taels of gold, and the remaining amount is subject to submission to the budget, which is not in accordance with provisions of the Civil Code 2005. And thus, it did not protect the lawful rights and interests of the involved parties. Besides, Ms. Tan initiated a lawsuit against Mr. Tam to pay her V&D 1,260,000,000, which was the amount that Mr. Tam received for transfer of the land area of 7,595.7 square meters, but she did not claim for the land use right. Meanwhile, Mr. Tam asserted that such amount of money belonged to him. Therefore, such amount of money was in dispute between the involved parties. As a result, it was not accurate for the first instance court and the appellate court to determine that the legal relationship was a dispute on reclaiming property. Part 5. Rules. Firstly, to set aside appellate civil judgment number 334/2006 DSBT dated August 25, 2006 of the Appellate Court of the Supreme People's Court in Ho Chi Minh City, and First Instance Civil Judgment number 04/2006 DSST dated April 28, 2006 of the People's Court of Sok Trang Province, on the dispute on reclaiming property between the plaintiff, Ms. LUient T Tan, and the defendant, Mr. LUient Tam, and Ms. LUient T Yen as the interested person. Secondly, to transfer the case to the People's Court of Sok Trang Province to reconduct the first instance procedures,